Your failure to appear on a repeated basis is a constant kick in the ding-ding to us, and I'm not going to take it. Mr. Maple, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. You guys have worked out an agreement where they're going to dismiss the unlawful carrying of a weapon in exchange for your plea on the DWI. You need to understand that this DWI will go on your record. It's going to be there for the rest of your life. It's even there after you die. It's important because if you ever get pulled over, an officer is going to look at your record. They're going to see a DWI. What do you think they're going to do to you if they smell alcohol or dope? Right. What we're doing today, from now on, you are facing a minimum of 30 days in jail. No more slaps on the wrist. Do you understand? So if I were you, I would never get in a car, even if you've had a sip of alcohol, a toke off a joint, whatever it may be, because you're taking a humongous risk. For $20, you click one button, you can have a car taking you perhaps $30. Anywhere you want to go, it's a geographical oddity why it's always $25 to $30 with Uber. You understand? Giving up the right to a trial, right to compel witnesses to on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you plead guilty.
All right, pause right here. 19 missed blows is not a small slip-up. In bond and probation cases, missed tests are treated almost the same as failed tests because the court assumes avoidance. Judges call this a zero-tolerance supervision condition, and once you cross that line repeatedly, excuses, cold weather, sleep schedules, usually stop mattering. Quick question for you watching. Should missed tests ever be forgiven if there are no positive drug results?
What do you do? Look at houses, remodel them, and fix up houses.
How much do you generally make a month?
1,500.
Okay. Yeah, but I take it you have to pay for somewhere to live, correct?
Yeah.
You have to pay for a vehicle, insurance, cell phone, food.
Yes.
When your monthly bills and expenses are paid, does it pretty much equal what you make, the $1,500 you make each month? Can you speak up?
Yes.
And would you be unable to pay a $3,000 surcharge based on your financial situation?
No.
Past witness.
Why on earth would we bend over backwards to help you when you don't give a rat's behind about this case? You have taken off 4 different times. You have failed to appear in this court for court settings. Why on earth have you taken off 4 times? What? So you just don't care about us and work is more important than court, huh? Actions speak louder than words, Mr. Maple, but you have taken off 4 different times. You are lucky that you are not in jail right now as it is. So why on earth would we help you when you don't even want to help yourself? Why?
Just trying to better myself. I should have listened to my gut and come here.
How much do you really make a month, Mr. Maple?
1,500 a month.
Who do you live with?
My dad.
Who are you here with now?
Just the lawyer.
I don't know. You know, it's
Young kid, nope. Not working, not a troublemaker. Just
here's my problem, Mr. Maple. My problem is that you've taken off on us over and over and over and over. Today, you're walking out of here and nothing is happening to you. My experience is that when we are too easy on people, they don't get the message and they act like a bonehead out there in the free world. And then they end up either picking up a new DWI or doing something else that's even worse. How do I know that you've learned anything about this? Because like I said, with how bad you've acted with us over the course of the last 7 months, you're skating out of here with a proverbial slap on the wrist. How do I know that you have learned anything, Mr. Maple?
Because I got my baby brother looking over me, and I gotta do better.
Here's what we're going to do. I will take off the $3,000 surcharge, but you will be required to pay the court costs in this case, for which are around $500. And I'm going to tell you now, if you don't pay it, every $100 you owe, you will sit in jail for 1 day. So you will be required to pay for something. And if you don't pay it, your butt will sit in jail for almost a week. Do you understand?
Yes, sir.
And I'm going to tell you now, the next time you come back, if you come back with the DWI, it's around $6,000 in surcharges, not to mention court costs. So you can look forward to around $7,000 in fines and fees. If you want to drink, if you want to get loaded, if you want to smoke, find another way. Do you understand? Because if you come back, it will be HE double hockey sticks to pay. Do you understand?
Yes, sir.
I'm suspending your license for 180 days. You are not allowed to drive at all. If you drive, that in and of itself is a Class B misdemeanor, just like a DWI, a driving on a suspended license case. Heed this warning. There won't be another one. Do you understand? All right?
Your Honor, any previous suspension from this incident, would it run concurrent?
Really? Really? No. No. There has to be some kind of consequence, man. Really? Taking off 4 times? I'm taking off 3,000 now, and he wants me to... I love you. Go.
Thank you, please.
It's
It's a really old case.
yes,
I've told him it's time to put this baby to bed.
yes.
Is there an offer in this case?
No, I
How come after 1,258 days, there is no offer?
was hoping we can get a gun safety class and dismiss.
It appears that was
Come up,
probably,
Mr. Adams.
the delay is probably due to the missing dash cam that's still outstanding that we do not have.
I don't care.
Yes, Judge.
Get on it now.
Yes, Judge. Well,
Why on earth would we allow you to do this class where you get to dismiss this case when it's 1,258 days and you've repeatedly taken off? It's a rhetorical question. You don't have to answer it. But I'm telling you now, I'm giving you 2 weeks to decide what to do with this case. The next time you come here, you will either accept a plea bargain agreement or I'm setting your case for trial. Do you understand? Not only that, I'm putting an ankle monitor on your ankle now. So
This is a key legal pivot. The judge is explaining probable cause, which is a very low legal standard. This does not mean guilt. It only means there's enough to keep investigating. A lot of people confuse this moment and think the case is already decided. It's not. The real fight happens later. But here's the drama. Once prior warrants enter the picture, everything escalates fast. Be honest, do you think police should be allowed to stack?
One, right? So I asked the court to withhold from, giving him an ankle monitor. The state's also missing evidence here. If we can come back and
last time we saw him was 3 years ago, Corey. So, I have sympathy in the fact that everybody has hard times, but your failure to appear on a repeated basis is a constant kick in the ding-ding to us, and I'm not going to take it. And I'm going to tell you now, I don't know why your bond is not at 10,003, because that is what it really should be. Your bond is at 1,002, and it's way off of what it normally would be. Because I'm telling you, your bond should be 10,003, because that's what they're normally set with a person who has absconded as many times as you do now. You're lucky that you're not in custody as it is now. Do you understand? But at 1,258 days, I don't trust you. And so the only way I know that I'm going to keep tabs on you is with an ankle monitor. And like I said, the next time you take off, and it doesn't matter what the excuse is, the bond is going to go astronomical. Do you understand, Corey? I'm sorry, but you know, if it were maybe 500, maybe 300, I would relent on
Okay.
not putting a monitor. But at 4 years or however long this case is, hell no.
I think that reflects his law abidingness, right? That he hasn't been in trouble, had any interactions with the police.
How do I know that?
Well, yes,
I don't know.
he hasn't been, he would have been in an orange jumpsuit, I guess, if he
Not
had to.
necessarily. I mean, we don't know how he's been out of county, you know, out of state. It just, look, you're walking out of here now. You're getting 2 weeks to decide what to do. You're not going into custody now. So you're still walking out of here, but I'm putting a monitor on you. And I'm telling you something else that I should make you pay for it, where it would cost you around $400 to $500 a month, but I'm going to eat it. So there's no excuse. Do you understand, Ms. Adams? But you got to understand that in court, we hold people accountable. You may be able to live your life like this outside in the free world, but not in court. We will hold you accountable. And the next time, get ready. Take a seat. Thank you. Of course.
Judge, for information,
Hey,
I have some from-
expedite it, whatever you need to do to get that body cam.
Okay, a week or two.
2 weeks. 2 weeks, yeah.
Judge, for the conditions, I have some from the magistrate as well for remain in Harris County. Did you want to keep that?
No, I mean, I've got a monitor, so I know where he is, you know,
So for all of the conditions, we have the GPS. Do you want that today?
right now.
And
Coming
then
down now.
any other conditions? No firearms, weapons, ammunition,
That's it.
drugs and alcohol?
No, it's fine. Okay. All right, Corey.
Thank you. I almost made the joke.
When we were here last time, he ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable
Oh, no.
and a no drive.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything and you're without any kind of devices whatsoever, right?
That was totaled and it's at my house right now. But I don't have I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Ms. Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
It's because she doesn't have a vehicle to put it on.
But you come back and you say, hey, Judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen. Ms. Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing, you know?
I understand. Would you consider setting her a new bond or do
Of
you?
course, 5,001. And then, you know, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
It makes me start.
Yes, ma'am. Thanks. Ms. Simmons Irvin, good morning, ma'am.
Good morning.
Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you, ma'am.
Yes, sir. On November 14th, 2024, officers were dispatched to a trespasser call at a business in Harris County, Texas. The officers made contact with a witness who stated the defendant was asked to leave the business but was refusing to leave. The officer walked over to the defendant and tried to inform her that if she refused to leave, she would be considered trespassing. The defendant would not listen and did not want to leave. The officer attempted to detain the defendant and place her in handcuffs, but the defendant kept pulling away, refusing to give the officer her hands. The defendant also braced her legs on the ground to prevent the officer from removing her, and the officer had to use a reasonable amount of force to place the defendant in handcuffs and remove her. The defendant braced her legs against the seat and door and prevented the officer from properly detaining her in the marked unit. And once in the unit, the defendant grabbed and pulled the officer's shirt, trying to pull herself out of the unit.
Okay, what store is this that she was in?
I have the address. I'll look to see if they have a store name listed.
Your Honor, ma'am, if I may speak.
Now's not the time. I mean, I've got a bunch of DAs here. Anything that you say, they're going to use it against you to prove guilt. You'll get the opportunity, I promise. Just now's not that time. How old are you, ma'am?
I'm 30 years old.
What do you do for a living?
I don't have a job. I'm disabled.
What's the nature of your disability?
I got cardio web, a hematoma, deteriorating spine, hole in my heart, pulled over ligaments, bilateral kidneys, asthma, cancer.
How do you support yourself?
Currently at this moment, I'm supposed to be receiving, I got my Social Security claim number, but they refused to give me my award letter. And also, I was currently supposed to be residing at Vermilion Apartments, and my contract, I guess, was switched.
I want to know about the case. I just want to know how do you eat? How do you get money?
I don't.
I need you to fill out an application for me, and then I'll take a look to see if you qualify. As a condition of your bond, don't go back to this place.
It appears to be a housing facility.
Okay, do not go back to this place, ma'am.
So I can't go back to Houston Housing Authority.
Whatever this place where they were trying to trespass you from, don't go back, ma'am. I'll provide you a lawyer today, and we'll talk about how we go forward, but I don't want it to be more bad blood, and I don't want you to go back to jail. If you go back, they don't want you there.
That's police brutality.
There's got to be some other reasonable way that we work things out, and we'll try. But you got to give it time, let things cool down. If you go right back after this issue now, you're begging for trouble.
Well, my contract is supposed to be terminated on 11/30th, meaning I still have an active contract. So what am I supposed to be doing about that in regards to that? I mean, I have my paperwork to prove
I
it.
can't give you legal advice, but we'll have you talk to a lawyer and figure out how we go forward. Okay. For the time being, don't go back though.
Okay.
Please, because it's only begging for bad blood. Okay. Yeah. So I need you to fill out an application for me. I'll have you sign a receipt of Victoria, and then we'll just have you take a seat while we find your lawyer. Okay. Please.
Invoke my constitutional amendment rights as well as my civil and civil rights.
Prosecutor remains silent. Yes, sir. No, sir. Back.
Is there a problem?
I honestly feel threatened by this courtroom.
And this is not the circus.
I'm
This is not a playroom.
clown.
This is a court.
I'm
And
very coherent and competent.
no one says you were incompetent, but you have bond conditions that you're supposed to live up to. And we've given you so much as we've also given you a lawyer, and you're supposed to treat everyone here with respect. And when you don't, there's serious consequences.
But is there a thing for self-representation? I know that is a third option as well.
Of course you can represent yourself. You can do open heart surgery on yourself too.
Well, I ask for fair representation in a speedy trial.
No one here does anything to hurt anyone. The only thing that we're concerned about here is public safety and that everybody gets treated fairly and with respect.
I
That
fear for
includes,
my life and safety against Harris County.
I don't know what to tell you about there, but you need to take that with whoever you feel threatened by. But here,
Harris County.
we need to protect everybody in Harris County.
Me and my children.
We've given you a lawyer. I want you to treat him with respect. And I want you to treat our clerks with respect, our bailiffs, and us. I'm not asking for much. The only condition I put on you now is to not go back to the location where you were allegedly trespassed from. They don't want you there. So that's why I'm telling you Now, don't go back. That's the only condition that we have.
In regards to my housing, which is my documentation right here, that should be submitted into my file. My stuff is supposed to be terminated on the 30th of this month, which I had probable cause to actually go and speak with Gary Baxter in regards to my housing contract. I also emailed informal hearing before November the 1st and haven't got a response back. So I had every reason to be at Houston Housing Authority.
You may have had a right to be there, but at some point, they're well within their right to say, look, we don't want you here anymore. You are creating a disturbance, so we would like you to leave.
Can y'all subpoena the cameras?
You can do whatever you want. You're going from here to here to here to here to here. Listen to what I'm saying and focus on this in the now. Don't start thinking of something in the future or something because you're not listening to what's happening now. You may have had a right to be there, but at some point you lost that because of the way you may have treated everyone and they didn't want you there anymore.
I'd like to file a hate crime against Harris County, the city of Houston.
Okay. You hear what I just said?
Hmm?
What did I just say?
Oh, I can't go back to 26.
This right here is the judge's philosophy in one sentence. Courts can show patience, but only up to a point. 5 years absent, a new felony, and now asking for mercy? From the bench's perspective, this looks like accountability finally catching up. Judges hate rewarding behavior that signals risk to the public. Final question for you. Is this tough love or too little too late?